right now. So now we are recording.
Perfect.
And I'll go ahead and share my screen, and then I'll need to do a little gymnastics to help that look the way we want it to look. Always tricky because all my buttons move. All right. And oh, thank you, Janice. I will enable transcription as well. All right, you should be able to see live transcription now. Let me know if you're having trouble finding it. Yep, it's up. Okay. Can everyone see that?
I can see it.
Okay, good. Oh, did I accidentally forwarded it when I was trying to click on something else. This is the tricky part. Okay, here we go again. I'll try and keep my mouse off of there. Nope, just went straight to it. Okay.
That's fine. Don't worry about the first page.
Okay, great, thanks.
All right, so this is the basics of covenant enforcement class. As Brenda said, my name is Jeff Smith. I am a partner at Altitude Community Law. We are the largest community law HOA firm in the state of Colorado. We represent about 25% of all HOAs here in the state. I am the head of our litigation department, and my day-to-day life is spent doing covenant enforcement for the vast majority. So that is why I'm teaching this class. A couple quick disclaimers. So I'm simply just providing information. I am not providing legal advice. I'm not your attorneys. So anything that I say is not actually legal advice. It's just giving you some opinions. We've tried to make this irreverent and humorous. It's not meant to offend anyone, but there are cartoons and things like that in there. So hopefully everyone takes them as what they are, which is simply just trying to make what is a rather boring topic a little more interesting. You'll hear a lot of depending, things depend, very basic lawyer answer from me when you're asking questions. You will hear a lot of that it depends on what your governing documents state. So all I can really kind of talk about is what most associations do or in generality. So just be aware of that in terms of answering specific questions. It's almost always going to depend on what your governing document states. So I won't be able to give you something that you could actually rely on, which is again why I'm not providing legal advice. If we go to the next slide, we have some additional resources. So if you go to my firm's website, altitude.law, you will be able to find tons of information. We have an incredible amount of resources on there. You have the entire Colorado Common Interest Ownership Act on there. We have lots of articles about covenant enforcement. We have lots of articles about the responsibilities of board members. Basically anything that could deal with homeowners associations, you are likely to find an article on our website for that. We also have a Facebook page and a Twitter page and LinkedIn information. I'm not gonna lie, I don't really use any of that. So they just kind of pop up there, more fun things or advertisement type things of something like this class, things along those lines. But if you're looking for substance, I would certainly go to our website. We also, on our website, you can sign up for our website. You can sign up for a blog and newsletter that we'll send out to your email address to keep you kind of updated on new HOA laws. All right, let's get into the actual class. So scope. So covenants cover everything that they are attached to. So covenants attached to your land. So how do you know what they are attached to? So the first thing that we're going to look at when you're covenants, and when we're talking about covenants, you'll hear kind of interchangeable words. So covenants, CC&Rs, declaration, all of those are going to mean that governing document that has the covenants in it. Oftentimes it's referred to as a declaration. Sometimes you'll hear it referred to as CC&R, which is conditions, restrictions, things along those lines. That is all the same thing. So I will typically refer to it as the declaration, as a whole document, or if we're talking about specific items within it, those would be the specific covenants. So how do you know what the covenant's attached to or the scope of what the declaration is? So you're going to want to look at your Exhibit A of the declaration, and that should list all of the property that is governed by this declaration. So it should, sometimes it'll be a lot and block type definition. Sometimes it will be a meets and bounds definition, but it's going to provide you with the information as to who do these documents govern. So that is important, because if there is a property that is not named in that Exhibit A, or an amendment to the declaration, then the declaration is not going to apply to that specific property. Another thing that we need to talk about is that declarations typically are there to deal with primarily the use of common property. And then sometimes they will have prohibitions on things that can be done on individual lots and homes. And that a covenant and property are inseparable once the covenant is recorded. So once it is recorded, it runs with the land. It's going to be there the entire time, the existence of the declaration. So it doesn't matter if a new person comes in, they're still going to be bound by this declaration. It's also important to recognize that an association is not created to handle everything which happens inside every home within the community. Typically, what these declarations are meant to do with is the exterior, things that people can see. So associations are there really to deal with kind of they're meant to keep property value up. They're meant to keep aesthetics looking a certain way. But we don't typically regulate what is going on inside an individual home. Sometimes with smoke or things along those lines, we might be able to do some type of internal control, but for the most part, it's all the exterior kind of things. And additionally, I mean, typically it's not our business what's happening inside someone's home, unless it's having an external effect outside of the home. All right, so the next slide we're going to talk about is kind of the purpose of the association. So the main purpose of an association is to maintain, preserve, enhance, and protect the property value of each individual parcel of land. Another purpose is to promote harmonious community living, preserve the common scheme, and preserve the harmonious design of the community. So when these declarants are putting together, or developers are putting together these communities, they typically have a general theme that they're trying to keep with. And the association's job, although we can amend our documents to change with the community, is to kind of preserve what that design is and make sure that the community is continuing to move as an entire whole. So that's important. Another thing that is really important that you'll notice here is there's nothing on here that talks about safety or security. The association is not there to provide safety to individual members, nor is it there to provide security to individual members. This is where associations get into trouble. If you remember back 10 years ago or so, the Trayvon Martin case down in Florida, the association had a community watch program, and the Trayvon Martin's family was able to sue the association and that community watch program because they had thrown out there that the association was supposed to be protecting the people that are within the association. We don't ever want to do that. The association, that is not what the association is meant to do. That's why you have a police force. The association is not set up to protect or provide safety or security for members. So that's important. Another thing that's important to remember is that covenants are recorded in real property records. There's a reason. The reason for that is so that everyone is on notice. So once it's recorded with the clerk and recorder's office, it is public record. Anyone and everyone can pull a copy of those covenants and see what they are. This is different than rules and regulations. Rules and regulations, which we'll talk about a little bit more, are developed by board members typically, and they are not a recorded document. So what is the reason that we care for the purpose of an association? It's because a court will only enforce rules which further the goals or purpose of the association and are reasonable. So that is why the purpose of an association is important. So the next thing we're going to talk about quickly is the governing documents of an association. All right, so this is not an exhaustive list, but these are kind of the main things. So the plat map is going to be a map that's going to have all the different property in the association. It's going to be delineated as lots. Sometimes you'll see an outlot, sometimes they'll be called tracts, but that's going to give you kind of the map of what the association is. The declaration of covenants, like we said, sometimes it's referred to as the CC&Rs or just the covenants or just the declaration. And the plat map, by virtue of the Colorado Common Interest Ownership Act, is part of the declaration. You also are going to have articles of incorporation, the bylaws, which are going to talk about mostly what your board members can do, how they're elected, how long they're elected, what kind of qualifications they need to have. You're also going to have more than likely some rules, regulations, policies. There's 9 policies that are required by the state that all associations have. We refer to those as the good governance policies. So those are always going to be found. Sometimes you might see a subdivision improvement agreement, an ODP or an official development plan, easement agreements. These are all things that are considered governing documents because they help to govern what is going on inside the association. All right, so the next slide is what is a covenant, excuse me. So a covenant is a promise which runs with the land. It restricts changes in the architecture, construction, or appearance of lots or homes, and conditions or restrictions on behavior of residents, guests, or visitors. So typically when we're talking about covenants, they're going to be something along the lines of you can only build a 2-story house, or a roof color has to be this. Maybe it's going to be something along the lines of if you or any of your guests damage common elements, that you're going to be responsible to pay for those things. These are what we're talking about when we are talking about covenants. So next thing is, so what else is there besides a covenant? On the next slide, we're going to talk about rules. So covenants are our strongest factor as to what is going on inside the association. The next step is going to be a rule. It's not going to have the same power as a covenant because rules are not going to be voted on by the association, by the membership. They're typically going to be approved by the board. And so what rules are really there to do is they are there to clarify or expand upon a covenant. If a rule is contradictory to something that is stated within the declaration or a covenant, then that rule is not going to be enforceable. Typically what we're going to be looking at, these are going to be statements of prohibited actions or uses. So when we're talking about a rule, maybe if it's a condominium, maybe there's a no smoking rule in the common elements. Maybe it's a dogs can't be more than 35 pounds, things along those lines. You also might see rules in the form of design guidelines. So maybe it's going to be talking about changes in architecture, construction, what the appearance of the lots or homes are to look like. And then again, as we already stated, that these rules can't contradict the covenants. So the next question is, can any association have rules? Short answer is no. Your governing documents have to give the association authority to adopt rules. Or if you are a Kiowa community, then the statute will give you authority to adopt rules. So there are some associations in the state and common interest communities that are not subject to Kiowa or are pre-Kiowa communities versus post-Kiowa communities. So it is possible that an association does not have the ability to create a rule, but the likelihood is that almost every association has that power. All right, so let's look at kind of the hierarchy of the documents in the law. So the highest thing that's in terms of hierarchy is going to be federal law. And the most typical federal law that is going to apply to associations is the Fair Housing Act, also referred to as the FHA. That's really the only federal law that truly comes into play on a regular basis with associations. Oftentimes you will hear owners talking about the ADA. And the ADA, while similar to the FHA, typically does not apply to an association. The only time the ADA is going to apply to association is if the association is a place of public accommodation. And so typically when that's going to happen is maybe it's a high rise, the first floor is commercial. And so in a situation like that, the ADA is going to apply to the commercial level, but it's not going to apply to the home area. Another area where you see it in single family homes is sometimes the ADA will apply if the association has a pool and that pool is open to the public. But if it's not open to the public, it's only open to the membership and their guests, then the FHA is going to be the only federal law that's going to apply. We also have state laws. That'll be the next step down from federal law. So the biggest state law that is going to affect homeowners associations is the Colorado Common Interest Ownership Act, commonly referred to as Kiowa. Kiowa is what basically governs all associations in Colorado with very few exceptions. There are some that are exempt from it. And depending on when the association came into place, it may be a pre-Kiowa community. Kiowa was adopted in 1992. So not all of Kiowa will apply to those associations that were in place prior to 1992. And then everything after 1992 will be subject to all of Kiowa. Another state law that comes into play with associations is the Colorado Nonprofit Act. All homeowners associations are nonprofit acts, or nonprofit corporations, excuse me. And so the Nonprofit Act does apply to associations as well. After you have federal and state law, then we kind of move down to city ordinances. Sometimes they're going to apply to associations. Oftentimes what will happen is the city has its own ordinances, city enforces those ordinances, the association does not. The association can't determine if someone is violating an ordinance. And just like the city won't come in and enforce the association's governing documents, the association should not be enforcing city ordinances. After we go through that, then the next level down is going to be the declaration and plat map. We already talked briefly about those. After the declaration and plat map, bylaws and articles of incorporation, those are kind of on the same level in terms of hierarchy. And then after that, we get to the rules, guidelines, and policies. And again, the rules, guidelines, and policies are the lowest in terms of hierarchy because it is not something that the owners approve. It is typically going to be the board that adopts these. So it's maybe 5 people that are creating these rules that are going to govern possibly hundreds of individuals. And so those are going to be given the lowest amount on terms of the hierarchy. Went to change the slide myself and remembered I'm not in control of that. Sorry, can we go to the next one? All right, so different types of rules. So there's rules and regulations. There's architectural guidelines. You may have pool rules if that is, if you have a pool, policies and procedures and resolutions. And really all of these are the same thing. They just kind of go by different names. Each of these items is considered the same in terms of weight in the courtroom. The reason for this is because, again, the board adopts each of these without a vote of the homeowners. If you're a Kiowa community, you have to have certain policies. Those that are provided there under 3833.3-209.5. And again, that's going to set forth the 9 policies that all associations have to have. And those policies are going to be a collection policy, an enforcement policy, a policy on adopting policies. There's all sorts of these policies that have to be, that all associations need to have if they're subject to Kiowa. Another thing that is important, sometimes your bylaws or maybe the declaration will talk about how you can adopt policies. And it may be possible that your documents require that a comment period take place from homeowners. So it may be that we're going to adopt a new policy. We need to send it out to the association for comment. But typically it's not going to be the association who is actually voting on it, not the membership. It's going to be the actual board. These rules, what we're looking for in them are we want them to be simple and absolute. So we want them to say something along like shall not. So we don't want them to be fuzzy. We want it to be like, you can't do this. You shall not be able to park anywhere except for on your driveway or within the garage. We don't want things that say we encourage or things along those lines because they're almost impossible to enforce. Again, it's strongest if we're trying to prohibit some type of action. It's strongest to have those in the declaration as opposed to the rules. Although if it's going to be in the declaration, then it's going to require a homeowner vote. So one thing that we talk about often is is this going to be a discretionary item? So it may be possible we may put in rules that there's something in the declaration that says all painting has to be approved by the Architectural Review Committee. So we may create a rule that says if you use one of these pre-approved schemes, then that is going to be pre-approved. The board does have discretion to kind of create these rules that'll help make the association move quicker and faster so that people aren't getting bogged down in some of the minutia that happens with associations. So oftentimes with these rules, you're going to have architectural review committees. You may have a pool committee, all of these things, and they might propose these rules. The rules will then be proposed to the board, and then the board will ultimately end up adopting them. Again, we don't want language that is things like should. We want it to be definitive language. All right, one thing to remember when we're talking about covenant enforcement, if we go to the next slide, is that you got to be careful for what you ask for. So one thing to remember is when you're dealing with this, more than likely, regardless what happens at the end of the covenant enforcement, this person is still probably going to be your neighbor. You're still gonna have to live with them. You're still gonna see them on a regular basis. This was a case where the HOA wanted this individual to paint their fence, and this is how the individual chose to paint it. Obviously, it's meant to be a little bit funny, but these things happen all the time. People get very angry. They don't understand why they're having to do these things. And so one of the biggest things to remember as a board member is that you want to work with these people because you're going to see them always. You're going to live next to them. It doesn't do anybody any good to try and set up these walls between the parties and I'm right, you're wrong, and the only way we can do it is this way. While sometimes we have to come down hard and we have to enforce what is going on, there's good ways to do it and bad ways to do it. And like everything, the more reasonable that the association can be in terms of trying to work with owners, and maybe we have to give them an extra month to be able to paint, maybe we have to do something like that. The more reasonable we look, the better it is for the association as a whole in the community. So in this next slide, you'll see that one of the things that's important with a rule or guideline or anything along those lines is it's important to spell out what you will and will not accept. So oftentimes, maybe it'll be something that'll say, we allow landscape statues or we allow water features. Maybe it's something broad like that. Well, these toilets are someone's art. This can be considered lawn art. And so if you aren't careful with what you are putting in these rules as what will be allowed and what will not be allowed, you're open for a lot of interpretation. And that's what leads to big lawsuits and lots of money from the association trying to fight something like this. So it's important to remember when we're looking at these things, that's why we want those definitive statements. We want it to make clear to owners what it is they can and cannot do. It's important to realize that the covenants, the rules and regulations, all of those things, they are meant to benefit the owners. The purpose of them is not for the association to be able to come down and say, no, we're in charge of you, you can only do X, Y, Z. What it is there for is for owners to understand that when they moved into this community, there are certain things that they can and cannot do. And these design guidelines, these rules and regulations, this declaration, it sets forth what I can do. And that way the owner knows exactly what it is that they have the ability to do on their property. All right, so now we're kind of diving into a little bit more of the actual nuts and bolts of covenant enforcement. So the first thing we got to do is identifying violations. Typically, your enforcement policy is going to lay out how you can identify a violation. So it may be an owner is allowed to file a complaint, maybe the association's manager, maybe it's a board committee complaint, board or committee complaint, or maybe it's external, something coming from a police department, a fire department, things along those lines. So for any Kiowa community, you must have a policy on how you enforce covenants and how you will collect fines and what alternative dispute resolutions you will handle. When SB 100 came out, and this was a state bill that required these nine policies, there was no penalty for not having these policies. But now if you don't have these policies and are not registered with DORA, then you cannot legally enforce your covenants. So it's very important that your association have these good governance documents. So one thing when we're talking about identifying violations, why do we care who complains? We care who complains because it's treated differently due to trustworthiness. If a manager sees something, most managers don't live in the community, so they have no axe to grind, so to speak. And so there's no real trustworthiness concerns. If a board member sees something, not their neighbor, then we can generally rely on it because again, there's no axe to grind. Now, if it's the board member's neighbor, it becomes a little bit more difficult. Same thing with the committee member. If it's someone that doesn't live next door to you, typically you're going to have a pretty high trustworthiness because you don't have any real axe to grind with this individual. If the complaint is from a neighbor, then we have to get some additional support. Typically, we recommend that all complaints be in writing, and hopefully that we have photos as well. It's important to know as well that complaints should not be able to be submitted anonymously. If you are bothered enough by something that is going on, you should be able to put your name on it. If you're not willing to put your name on it and therefore be willing to testify in court as to what you saw, chances are the association is not going to have the power to move forward. Now, if we have the ability to go out and see the same violation and we go out and do it, then that's one thing. But if an owner says this person's been having a party, they've been really loud, but I don't want you to say who I am because I don't want them to retaliate against me. Typically, we're going to advise the association that there's nothing we can do about that. The person who's having the complaint made against them is entitled to know who is making the complaint. It's just simple that is what needs to happen. Okay, so one thing when we're talking about all of this is once the violation's been issued, the fine is there. Before a fine can actually be put on someone's account, the owner is entitled to notice an opportunity for a hearing. That opportunity for a hearing needs to be in front of an impartial decision maker. Yes.
Sorry to interrupt. Am I still on the right slide?
You are.
Okay, just want to be sure.
You are good. They kind of overlap here for a little bit. So impartial decision makers. This is something that tends to confuse homeowners. They think that an impartial decision maker means it can't be the board. However, Kiowa specifically defines what an impartial decision maker is. And ultimately what that is that unless the board member is gaining some value more than any other member of the association, they are not going to be deemed not to be an impartial decision maker. Ultimately, it is set up that the board is the impartial decision maker. Maybe it's a design review committee, something along those lines, but that is who is meant to be the impartial decision maker. Whether or not you think they are against you or not against you, that is irrelevant. It simply comes down to whether or not the individuals who are making the decision are gaining something more than any other member of the association would be. Okay, we can go to the next slide now. So enforcement options, different ones. The board could take no action. The board may rely on external resources, may rely on internal resources. Maybe we need to go to alternative dispute resolution, which would be like a mediation or an arbitration. Perhaps the board is going to fine, or maybe the board is going to take the action of filing a lawsuit against the owner. We go to the next slide. So what happens when you agree with the actions of a homeowner that you know are a violation? So in this case, home for sale by owner because my neighbor is not a very nice person. Do we still have to enforce if we agree with this individual that the person next door is not very nice? The short answer is that if the association is aware of a violation, the association should be enforcing those violations, whether or not they agree or disagree with what is going on. One thing that we always are advising boards that if they have rules that they don't want to enforce, it is much better to change that rule than to simply not enforce a rule. So if there is a rule that says you're not allowed to have sheds in the community, but over the course of years, sheds have been put up there, the current board doesn't think that there is any reason we shouldn't have sheds. Rather than not enforcing the rule that says no sheds, we should amend the rules and take away that no shed provision. That is a much better way to do it. Sometimes it's more difficult if it's a covenant. If it's a covenant and it's there, the board is aware of a violation, the board should be enforcing. And we'll get back here a little bit later and talk about signs and flags because there's new law that has come down here where in the past we would be able to prohibit a sign like this that you see in this picture. Now, because of the recent law that was just passed in Colorado, we can no longer govern content. And so owners are allowed to put any kind of content they want on these signs, and they can have something like this. They could have something that is discriminatory. They can have all sorts of things that they want on there. Associations are no longer allowed to deal with content, which from an association standpoint is probably great because if someone puts up this sign and a neighbor complains to the association that you need to do something, the association can simply say that pursuant to state law, we are no longer allowed to deal with that. If you have an issue with that, you should contact your congressman and see if you can get them to change the law, but it is what it is at this stage. All right, so next slide is we're going to talk about kind of the no action. So there is a duty to enforce covenants. Oftentimes there is going to be some type of political decision that's going on in terms of there's going to be warring factions within the association. There's no requirement to enforce each violation. So what that is basically doing, there is some discretion for the board. So when we are looking at things, perhaps someone put on a roof that did not match the proper color. The association, for whatever reason, did not realize that this roof was put on with the wrong color until a year and a half after the roof was put on there. At that stage, the statute of limitations had run. And so the association could not successfully go to court and require that this roof be changed because the statute of limitations had expired. So in a case like that, we would advise the board that you can't enforce this violation. Now, simply not being able to enforce that violation doesn't mean that if someone else puts on the wrong color roof and the association catches it in time, that we can't enforce against them. Everything's going to be a case-by-case analysis. Courts are going to apply the business judgment rule, which ultimately is going to mean that as long as the association is informed, they're consulting an attorney or a professional, and they're relying on that judgment, on that advice, then more than likely they're going to be protected by the business judgment rule, and the court is going to agree with what they do. Associations also want to make sure they're documenting their reason as to why they are making whatever action they're going to make, especially if they're not going to take action. So if you choose not to enforce, you may eventually be supported on that in court, but you may lose your cushy position as a board member. That's kind of the political decision. So everything, I mean, the best way to change, if you don't like what a board member is doing, is at the next year's election, you vote them off. So that is what that's kind of talking about. Regardless what you do, there's always going to be some people who will be mad you did not enforce something, and some will threaten to sue. They are always going to be trying to put some pressure on board members. The board member's duty is to treat the association like a business. The business is to maintain property values and the look of the community. If you choose not to enforce, you need to have a reason as to why we're not, like the statute of limitations has expired, or that you don't have the ability to prove it. One of the things that we'll see is sometimes with dog poop, they'll have a complaint that we know that it's this dog that is leaving this dog poop around. We need you to find that individual. Well, unfortunately, we don't have any pictures. This is not an association that is taking DNA of different dogs to go back and see whose dog poop it actually is. So in a case like that, more than likely, we're not going to be able to try and enforce because we don't know exactly who is the violator. So there are sometimes reasons that we can't enforce. So if we go to the next page, it briefly kind of talks about the business judgment rule and having to enforce. Again, we are going to be able to make decisions. There is some discretion. So if we go to the next slide, it'll kind of lay out to us what the business judgment rule is. If you look at that case that was cited on the last slide, it will lead you to kind of the hallmark case for the business judgment rule here in Colorado. But under the business judgment rule, a director is not liable to association or members for any action taken or omitted if the director first acted in good faith, second with the best interest of the association and acted prudently, so therefore informed. So as long as your board members are acting in good faith, and that's kind of an arbitrary decision, but more than likely they are, with the best interest of the association. Again, this is somewhat arbitrary in terms of each individual might have different understandings of what is in the best interest, but the court is typically going to think that a board member is acting within the best interest, and if they're informed. So if the board members have gone out and gotten a legal opinion, or relying on one of their management professionals, something along those lines, typically a court is going to agree, even if it disagrees with what the board did, it's going to find reason that the board had the right to make that decision. And that's important. We don't want, board members are volunteers. They're not legal scholars. Even legal scholars don't always know exactly what is going on with the law. So to try and hold them to some standard would absolutely stymie any kind of functionality of your HOA. And so that's why this business judgment rule is important. So if we go to the next slide, this is kind of talking about the dog poop issue. This is the lineup. We get these complaints all the time. So sometimes when you can't prove a case, it's a good time to take no action. So I can't tell you how many times that I get an email from a board member or from just a member of the association who says, Johnny's dog is pooping outside of my yard. Every day they poop outside it. When we ask the individual, do you have any proof? Have you actually seen Johnny's dog doing this? Did you take pictures when it was? Inevitably, they're going to say no, but that it's the only dog that is around. It's the only dog that could be doing it, etc. Again, that's not going to be enough proof for us to be able to prove that this is some dog's poop. We have no idea. It could be any dog that's roaming through the neighborhood at any given time. We have to be able to have evidence to prove to a court what is in fact taking place. So again, this is a time where we might not be able to take an action. All right, external resources, which is our next slide. What are some things that we can use? So the health department, building zoning department, law enforcement, fire department, building code enforcement, animal control. These are all things that associations can and should rely on when they can. So if you have a hoarder and you're in a shared wall community or a condominium, something along those lines, that hoarder can cause serious issues. Maybe it's going to be leading to bed bugs. Maybe it's a fire hazard. So we may need to get both the health department and the fire department to come in and do a wellness check and see if they can deal with the underlying behavior, the hoarding. Those entities, these external resources, tend to have a lot more power than the association has. Building zoning department, if there is an issue with setbacks, if there's an issue with not getting proper permits, that's a great place to go to. Obviously, law enforcement, anytime anyone feels threatened for their life, don't call the association. Or if they're concerned they're going to get hurt, don't call the association, call the police, get a restraining order, use those things. The association is, again, not set up to protect you. They are there to make sure that your property values stay up. Again, barking dogs, a great thing to do is call animal control. It is always a good place to go. And they'll come out and either the animal is actually being a nuisance or it isn't. Especially with dog bites, things along those lines. The association really isn't the proper avenue. And so anytime the association can use an external resource to help solve a problem, that is beneficial to all of the members, because it is not it's not an expense to the association. Every time the association has to contact my office, that is going to be an expense to the association that all of the members are paying. In some cases, we're allowed to put it back towards that owner who's causing the issue, but at the front, on the front end, it's always going to be the association that's paying it, and then you have to go back and collect against the owner. All right, so some internal resources. These things are going to be found in your declaration, possibly in your bylaws. So if we go to the next slide. Some of the options that we can do when someone is violating the covenants, perhaps we can suspend their voting rights. Maybe we can suspend the use of pool or rec center or any other amenities. Shut off the garbage collection, stop cable or internet, towing, utility shut off, and self-help. So we'll kind of go through and talk about these a little bit. It's important to realize that in order to do any of this, you have to have it in your governing documents. So you can't suspend someone's right to vote unless it is provided for in your declaration or in your bylaws that says if someone is not in compliance, maybe that's delinquent on assessments, maybe it's a covenant violation, that you have the ability to suspend their voting rights. Now, granted, most people who are violating the covenants and or not paying their dues typically aren't the people that are going to vote. So suspending voting isn't usually a big deal. Doesn't usually affect them that much. On the other hand, if it is May 31st and a parent shows up with little Johnny and Sue wanting to use the pool and their key card doesn't work, that is a huge incentive for owners to come back into compliance. So when that happens, they come, they reach out to the management company typically, and they're yelling as to why they can't use the pool. The management company explains to them it's because they have some type of a covenant violation. Maybe it's a painting issue, maybe it's a weeds issue, who knows what it is. But in order for them to come back into compliance, they need to do X, Y, Z. And once that is done, they can then have use of the pool. That is a great tool for associations to get compliance of a covenant enforcement. In terms of shutting off garbage collection, is not something that we would recommend. All it does is exacerbate problems. If you have a property that isn't complying with the governing documents, and we then shut off the garbage collection for that unit, all that's going to happen is these people are just going to put the garbage outside of their unit. It's going to keep building up. It's going to become disgusting. It's not usually a good tool to do it to gain compliance. Stopping cable and internet, especially if you're in some type of a condominium townhouse kind of situation, that can be a very, like shutting off the pool or rec center, can be another great way to get people into compliance. People rely on their cable and their internet all the time. And it's not a life, it's not like water or power, which is like utility shut off, water, power, gas. We would never recommend turning off their utilities, but stopping something that is like cable or internet, that is really a luxury, that is a great way to gain compliance. Fastest way for an association to get sued is to tow someone's car. It happens all the time. Cars get towed all the time. First, you have to have the power in your declaration to tow, and then you got to make sure you're following all the steps. But even if you follow all the steps, it is not uncommon for the association to get sued anytime they tow someone's car, because this is how people get to work. In order for the people to get there, they now have to catch a cab or a ride down to the tow company. They got to pay an exact change. It's a huge inconvenience, and they will oftentimes sue the association because of that. They don't win all that often, but it is a quick way for the association to get sued. Self-help is in almost every declaration. There's going to be some provision that says if an owner is not complying with the governing documents, the association has the ability to go in and fix those violations and then charge the owner back for fixing them. Typically, we would not recommend to an association to use self-help unless a property is vacant or an owner gives you permission. We would never recommend to an association to have someone go onto someone else's property without their permission, because we don't want someone to get shot. It happens, and there's no violation that is big enough that it's worth someone being shot or the risk of that. So rather than using self-help, the better option is to go to court, get a court order requiring the owner to do it, and then we go through those steps. So the next slide is going to talk about self-help briefly to give you a little, it's an important enough one that we have our own slide on it. So first, you have to make sure there's authority in the declaration. Again, most declarations are going to have it. When to use it? Again, we don't want to use it unless the property is vacant or the owner has given us permission. We also, when we're invoking self-help, we want to have law enforcement there. We want to make sure there is someone outside of the association controlling the situation. We also want to make sure we're videotaping it, because it is not uncommon for an owner to then claim that the association has caused property damage. Before you go through self-help, you want to make sure that you've contacted your attorney and they walk you through the process. And we want to be in and out as fast as possible. We want to be there for the shortest amount of time that we can. All right, next steps, or next slide, alternative dispute resolution. All right, there's different types of ADR. ADR is it's a good tool, and it's a tool that almost all courts are trying to rely on right now. The dockets of these courts are extremely busy. So anything that a court can do to try and alleviate some of that burden on their docket, they're going to try and do. So in almost every county court case, you're going to have mandatory mediation. In places like Boulder, which is amazing, they have a free mediation setup where you can go. It's great for neighbor to neighbor type disputes, or a neighbor dispute with an association. It's free. The mediators will reach out to both parties and they will discuss, try and get you into a place where both parties can discuss the issues and come to a conclusion. Some of the other cities will also have it. And then outside of that, once you're in court, most courts are going to require it. Some declarations will have ADR provisions, and we'll talk about certain claims that have to go through either an arbitration provision or a mediation provision. Additionally, all associations need to have an ADR policy. That ADR policy may be as simple as we encourage any party before filing a lawsuit to explore alternative dispute resolution, or it may be as, sorry, I apologize, Brenda. Apparently the mediation is not free in Boulder, but it is extremely cheap. Very cheap. So sorry about Brenda, I misspoke there. So some of them will be as simple as just we would recommend it, and some of them will be, if it's this type of a claim, we require you to go to mandatory arbitration, or we require you to go to mediation before you can file a lawsuit. So that is going to be dependent on your documents, and you need to look at them before you take any actions. Typically, mediation is going to be relatively cheap, and it's not going to be as lengthy as a trial would be. Arbitration, on the other hand, can be just as costly and just as expensive and just as long as a trial would be. Typically, we try to avoid arbitrations in the association realm, we'd rather be in front of a judge that has a better understanding than arbiters. But sometimes you have to. Typically declarants, they want to be in front of arbitration because they want to be in front of someone who's knowledgeable about the construction industry, as opposed to a judge who's looking at a little larger scale. But it just depends on what we have. When to use, if you're required to use it, we need to go with alternative dispute resolution. If we're not required to use it, it still is a great way to try and resolve issues. Most of the time, these issues flare up because neither side actually takes the time to sit down and talk to each other. When you get those parties together and you have a neutral person there kind of helping facilitate the conversation, 90% of the time, you're going to reach some type of a settlement. So mediation has a great value in these covenant enforcement type disputes. So the next couple slides are just kind of some cartoons and pictures. So this first one is talking like Halloween's coming up. We should build a haunted house with scary fog and noises and a big addition to the front of the house. I mean, the kind that violates every HOA rule. It's not our find. So you'll find lots of cartoons that are joking around about HOAs. HOAs are always seen as being overbearing. And really it's a misconception in my mind as to what an association's responsibility is. Associations are there to protect property values and to ensure uniformity. If you are an individual who wants to do whatever they want to do in their property, a homeowners association is not the place for you. When you buy into an HOA, you give up certain rights, and those rights are spelled out that you're giving up inside the declaration and within the rules and regulations. So it is important to know that when you move in there, it is not that you can do whatever you want on your property. It is you are subject to all of it, just like everyone else. And that is a hard lesson for a lot of people to learn, especially out here in the West, where almost all homes, especially homes that are built after 1975, are going to be in some type of association. But it's important to recognize that when you move into them, you are responsible for abiding by those rules. And originally, covenants were set up, restrictive covenants were set up to segregate communities. They're set up to keep African Americans out of white communities and other people of color outside of communities. Back in the 50s, that changed with a case out of Missouri. And then from 1950 to 1970, you no longer saw the blatant kind of no African Americans allowed in the restrictive covenants, but then it moved on to you had to have certain amount of features in your front yard, things that were economically meant to set up to detract certain individuals from moving into certain communities. And then once you get into the 1970s to now, it really has shifted to, it's no longer about trying to keep people out. It is about developers trying to keep their costs down and keep uniformity within a community. And so that everyone knows exactly what it is they are moving into and knows what they can and cannot do. So it's important to recognize when you move into an HOA, you have given up a bunch of your rights, and you have turned those rights over to the association to be able to enforce certain things. And so when a neighbor complains about too loud of music or a light is too bright, more than likely the association has the ability to enforce those kinds of actions. If we go to the next slide, since we're kind of coming out of the Halloween season, we're looking at different decorations, and one of the issues that we come up with, so I think we're going to be on slide 25.
Sure. Thank you for that. I don't know why that happened. Let me pop that back up. No, that is not what I said. There we go.
Perfect. So this is kind of a classic example of a typical house dressed up for Halloween. You would be surprised how many times I get calls about this, that these lights are too bright or these decorations are too scary. And on the flip side, we love it. We love everything that's happening there. These are the things that we are constantly dealing with. And this is what associations and volunteer board members are constantly trying to determine. Is this a violation or is it not a violation? And it's important to realize that a lot of these things are not cut and dry. It's difficult for these board members and volunteers to try and come up with whether or not this is a violation or not a violation. So I would urge you to give board members some patience and to talk with them, communication is the best way for a community to come together. And so if we can have the communication, it's one of the good things about what this pandemic has brought is that a lot of boards have moved to Zoom meetings, and that has really increased the number of people that can attend the meetings. And so if we can have more dialogue, the better the association is going to be. All right, let's talk about fines. All right, so in order to issue a fine, first we have to have the authority to do it. It's important, when do we have the ability to do it? We're going to talk about due process, reasonableness, as well as collection of the fine. So in terms of authority, the first step is we have to make sure that we have an enforcement policy. We have to make sure that we have a collection policy. And we have to make sure that we have something in the declaration that allows the association to enforce the covenants. Assuming you have all of those, then we'll have the ability to fine. Now, when do we want to use a fine? Fines, again, are not meant to be money generators for an association. They're meant to gain compliance. So if an owner, typically in your enforcement policy, what's going to be said is the first thing is going to be a courtesy notice. Owner, maybe you weren't aware of this, but you left your trash cans out for too long. You need to bring them in. This is just a courtesy notice. Please comply with the governance going forward. Owner does the same thing next week, leaves it out. In this case, we're going to send our second letter. The second letter is going to say that you did not comply with our first request. You have 10 days to come into compliance or request a hearing. If this does not happen, you're going to be subject to a $25 fine. If that happens, again, we have to make sure we're giving them notice and opportunity of a hearing. If we go to the next page, we'll kind of talk about the due process steps. So what we have to do every time before we can issue a fine is we have to notify the individual of the violation and the right to a hearing. Again, we need to be prepared to disclose the name of the complainant and copy of the complaint pursuant to different statutes. So 7/136/102 is part of the nonprofit code. 3833.3 317.2 is part of Kiowa, and that's going to be discussing what goes on in terms of the impartial decision maker. Then we hold a hearing and we issue a decision. So again, the first step is notice. We got to give them notice. So say it's an issue of the individual is not picking up his dog's poop. We send a notice, let's not do dog poop. We'll say instead of dog poop, the individual is walking their dog without a leash, and the declaration requires that all dogs be on a leash at all times. January 1st, we notice this for the first time. We send a courtesy notice to the individual saying, look, pursuant to the declaration at this spot, you have to walk your dog with a leash. Please come to compliance. If you disagree that you are in violation, please contact the board and we can set up a hearing for you. Then on January 10th, again, we see the owner walking the dog without a leash. In this stage, we send a notice of fine. So we would send, again, you have not been in compliance. It was noted on January 10th that you were walking your dog without a leash again. A $25 fine will issue against you. You have the right to have a hearing. If you don't request a hearing, then the fine will issue. So at that stage, the owner, if they contact the board, we have the hearing. The owner has the ability to explain to the board why he or she does not believe that they are in violation of the covenants. The board will then make a decision. They'll hold the hearing, they'll make the decision, and we want them to send a written decision to the owner. And if that decision is yes, we find you that you are not in compliance, then the fine issues. And that's the proper process. Oftentimes what you will see happen is we'll skip that notice of opportunity, that hearing phase. So what'll happen is the January 1st letter is issued, and then we see them again on January 10th. And on January 10th, we send that second letter, but we also issue the fine on that date. And that's not proper. What we need to do is we need to send the letter, give the owner opportunity for a hearing, and then once the hearing has taken place where the owner doesn't request it, that is when the fine should actually be applied to the ledger. All right, let's go to the next slide. Ensuring procedures are consistent with policy. So some of just good practice things to do. One, make sure you're consistent with your process. One of the most common things that we will hear anytime we are suing an individual for not following the covenants is that we are selectively enforcing against them. It's typically not happening, but one way that we can make sure that we can show that it isn't is by being consistent with our process. We want to create a system and we want to use it consistently. Don't have a system that is different than your covenant policy. So if your policy says one thing, make sure you are following it. If you as a board member or as the board do not like what your policy says, don't choose not to follow it. Adopt a new policy that goes by the way that you want to do it. It's much better to follow, to change a policy and follow it than to keep a policy in place but not follow it. Always send applications to one spot. So when we're looking at design review requests and things, we want to make sure we're keeping all of the applications, their records of the association. And when we're keeping responses, we want to make sure we're keeping all these documents that are either going out of the association or coming into it. These are records of the association that we need to keep. And if someone needs to inspect them later, we need to have them. When we're talking about a letter, like a fine violation letter or a courtesy letter, we want to make sure that the letter describes the alleged rule violation. We want to make sure we restate the actual rule. We want to state what the penalty is if the owner does not come back into compliance. We want to tell the owner what specifically we want them to do. So if it's pull the weeds or if it's paint your house, we want to spell that out for them. Again, we want to state what the consequences are if they don't take that action. So if they fail to paint it, they're going to be fined. Or if we're further along the line, they're going to be turned over to the attorney. We want to make sure that we're providing that opportunity to appear at the hearing and what the consequences of not appearing are, which are the fine is going to issue. So these are all important things. We want to have a checklist. It's great if the board has a checklist to go through for each of these processes. If you have a professional management company, they kind of have their own checklist, and so they help to keep you on track. We want to make sure we're posting the process and procedures either on websites or mailing them out in newsletters. We want to, again, these policies, these rules, these covenants, they're there to help the owners. So we want to make sure we're making it as easy as possible for them to get their hands on these documents. So more than likely, they got all of the documents when they closed on the house, and more than likely, they never read them. I mean, I'm an HOA attorney. This is all I do all day long. When I moved into my house 2 years ago, I did not look at my governing documents. And if I'm not going to do it, the likelihood of most people doing it is pretty small. So they usually got it there. But if we can have a website where owners can go and pull these up on their own, that is very helpful and a great thing to have. Most management companies are going to have websites for you. It's part of their services. You should use those and make sure we're getting all the governing documents up there. Obviously, we want to make sure that we're complying with Kiowa. We want to make sure that we're complying with the nonprofit code. And again, that's why associations should be relying on their legal counsel and should be relying on professional management. The associations that get into the most trouble are the ones that are self-managed, or they have someone on the board that's an attorney who does not do HOA law, and they think that they can save money for the association by drafting these documents for them. And typically, because of how specific Kiowa is, they end up doing it wrong, and it ends up costing the association tens of thousands of dollars on the backside. So again, make sure we have policies and make sure we go through it and follow those policies. All right, the next slide is going to be talking about legal action. We could go to the next slide. Perfect, thank you.
Sorry, it was feisty.
So legal action. What does it mean to use legal action? It could be a demand letter. It could be a lien. Sometimes we will put on use of covenant violation liens. So we'll do a covenant violation lien. That is something that we file to put on notice any individual, a potential buyer or a mortgage company, something along those lines, that there is a issue with the property that needs to be dealt with before the property can sell. Or it could be a lawsuit. When do we want to use legal action? Again, we want to try and work with the owners as much as we can. Sometimes it just doesn't happen that way. We're going to go through our whole policy. Typically, the enforcement policy is going to have a courtesy letter, and then a first fine letter, second fine letter, third fine letter, and then it'll be turned over to the owner. Turned over to the attorney, excuse me. If the owner hasn't responded during those times, there's not a whole lot the association can do to try and resolve the issue without going to legal counsel. Sometimes the owner will respond, but won't like what the association is saying, and then still will choose not to come into compliance. Again, in a situation like that, it's more than likely that it's going to have to go to the attorney. When it comes to the attorney, we're going to send a demand letter. More than likely, we're going to file a covenant violation lien. And then if the owner still hasn't complied at that stage, then we're going to file a lawsuit. When we file a lawsuit, we are going to be seeking a temporary injunction and possibly a permanent injunction, depending on what the issue is. We're going to be looking for removal or modification of what is going on. We're going to try and collect the fines, and we're certainly going to collect the attorney's fees and the costs. One thing that you got to pay attention to when you're talking about legal action is who has the ability to enforce. It's going to depend on the declaration. Sometimes it's going to be the association through the board. Maybe the declaration says that the architectural review committee or the design review committee or some other committee has the ability to enforce. And then almost every declaration is also going to say that individual homeowners have the ability to enforce the declaration. So those are all things to be looking at when we are trying to determine what our best process is to gain compliance for the association. So this next slide is another picture, kind of a remember things go bad. So one thing to remember is that in addition to the time and cost to the association, at the end of every case, even if you win, more than likely the person is still going to be in the community and maybe still your neighbor. So the story of this is a case out of California. The home that this window is facing got the association to file a lawsuit against this individual who had built a 2-story house, and they were only entitled to build a 1.5-story house. Because of that, the owner had to rip off the second floor of the house, and the new design was this, with a window that appears to be giving the middle finger to that owner. So again, it's an important thing to remember that these individuals are your neighbors moving forward. The more reasonable we can be and the more we can work with them, the better off we're going to be. Again, it's not always possible to work with them, but it is something that we always strive to try and do. All right, different types of defenses that you will see in a covenant enforcement action. So the defense attorney is likely going to try and challenge the covenant rule or guideline. They may challenge procedure. They may challenge the decision process. Maybe they're going to talk about abandonment or waiver. So one of the first things they're going to do is, was the decision reasonable? What factors does a court use to determine reasonableness? First, is it the decision within the scope of the ACC authority or the board? So the first thing we got to determine, is there actually a covenant or rule that is prohibiting whatever is going on? Or does the ACC or the board have the ability to actually say you can't do whatever it is you are trying to do? If we're talking about a rule, is that rule consistent with the restrictive covenant? Again, was the decision that the board came up with or the ARC, was it based on adequate investigation and adequate facts? So did the board do anything to investigate that this house was painted the wrong color? Did they go out and look at it? Anything along those lines? Next thing we're going to be looking at, the court's going to look at, is did the ACC give the applicant an opportunity to address the concerns of neighbors, or is the decision captured in writing? So when we're talking about things like abandonment, it's a pretty rare defense that would be granted. Typically what that's happening, defense attorney might come in and say, look, the association has never enforced this provision, and therefore the provision has been abandoned and can't be enforced. Courts are pretty reticent to agree to that type of a argument, but sometimes it happens. There's a case out of Texas that happened 3 years ago where there was an abandonment. I'm not aware of any Colorado case law that has deemed that a HOA has abandoned a specific provision within a declaration, but it is possible. There is case law out there in other states. Waiver is simply going to be talking about the same thing. It's kind of like abandonment in terms of we haven't enforced something for long enough, and therefore we're no longer allowed to do it, no longer allowed to enforce it. If we go to the next page, we'll see a few more defenses. The two biggest ones are selective enforcement and statute of limitations. Latches and estoppel are both kind of equitable defenses. And so when we're talking about what those things is going to be, an owner submits a plan to put up a fence. The association says, yes, you can do it. And then a day later, they look at it again and they realize, oh, shoot, actually what you proposed is something that goes against the covenants. But at that stage, the owner has already purchased the materials to build the fence. At that stage, the association is stopped from being able to do it. That's because the owner got a decision, relied on that decision to their detriment. At that stage, there's nothing more the association can do. In terms of selective enforcement, this is one of the biggest things that gets brought up by defense attorneys. They are always going to say that their homeowner is being treated differently than every other homeowner. It's going to be there. They might throw in a discrimination claim in there. They might throw in different things, but they're always going to be trying to say that their client has been discriminated against or selectively enforced against. And they're going to be able to find some other property in the community that maybe has a privacy fence, when a 6-foot privacy fence, when every other privacy fence is 5 foot, or something along those lines. The way we counteract selective enforcement is, one, we have to show all the different enforcement actions that the association has taken, which tends to be a lot. And the best way is to do it is to make sure that everyone is being treated the same way. So we are constantly harping on board members, and they are typically very good about it. They enforce the same way. Now, sometimes people think it's selective enforcement because no one ever drew it to the board's attention that there's a violation going on over here, but someone drew it to attention that there's a violation going here. That's not necessarily selective enforcement. The association can only enforce what it's being informed against. So unless they see it, they have to rely on owners to tell them what's not happening. So that is something that happens a lot. If the association knows that a violation is taking place, it needs to be enforcing it. But if it doesn't know, then there's no way for the association to enforce. In terms of statute of limitations, what we're talking about here is when we are talking about a physical change to the property. So maybe it's the owner painted the house a new color, or maybe they put on a new roof, or maybe they built a shed, or they built a fence. Something like that, that is a physical improvement. The association has 1 year from the time that it knew or should have known of the improvement to file a lawsuit. If it does not file a lawsuit within that 1 year time frame, statute of limitations has run, and then the association likely does not have any recourse. So this is a big deal, comes up a lot, and something that all boards need to pay attention to, and management companies. But that's one of the biggest offenses that you will see at all times. If we go to the next page, you'll see another slide on statute of limitations. Again, talking about the 1 year for structures improvements. It's from the date of discovery, which is when you knew or should have known. This is different though than a continuing violation. So a continuing violation would be like a maintenance issue. So weeds. If someone hasn't pulled their weeds for a year, each and every day that they haven't pulled their weeds, that statute of limitations starts back over. Same thing where instead of the owner not painting the house a different color, in this case, if the owner has allowed the paint to fade or it's chipping, that is a maintenance issue, and that does not have a statute of limitations. Each and every day, that violation changes a little bit, which restarts the statute of limitations. And so those are continuing violations, and they are not subject to that 1 year time frame. All right, bear with me for about 10 more minutes, and then we'll get to some questions. All right, judicial standard of review. So rule and covenant isn't enforceable. So enforceability has to do with whether the declaration was adopted properly and recorded, and or whether the amendment was adopted properly and recorded, and or the rules were adopted with the authority and proper. So what we're talking about is, one, sometimes a declaration may have been amended improperly. Maybe they didn't go through the right process. You have 1 year to challenge an amendment that has been passed. So if you are within that 1 year frame and the amendments say it's a ban on short-term rentals, the amendment wasn't adopted properly, and the association is trying to enforce that rule. If they sue a homeowner saying you're doing short-term rental, that homeowner would likely file either a counterclaim or put an affirmative defense that the association didn't have the authority to adopt this because they did it improperly, or enforce it because they did it improperly. So a court is going to look, did the association adopt it properly? If the court finds that it didn't, then it's not going to be enforceable. So again, it's important in these scenarios to make sure you're using an attorney. There are 4 or 5 firms in Colorado that specifically do HOA law. All of us do a good job. So I would highly recommend that you use any of our firms to make sure when you're doing this that that you're going to an actually HOA specific firm. It is very important. Kiowa is extremely specific. And so when you're using people that just dabble in it, it tends to cause a lot more issue. Next thing that judicial standard is going to be looking at is, did we follow the procedure, the documents, the statute? So once we've adopted the rule, is there a procedure that we had to follow with it? Were we acting within the scope of authority of the declaration or the rule? Or are we doing something that is outside of it? And again, did the association act reasonably and in good faith? There's always going to be a stigma attached to associations that they are big and bad, and they get called Nazis all the time, or the Nazi police, or the Karens, or whatever name they want to give it to them. There's just a bad taste in people's mouths about associations. So that is something that we are always having to overcome in the court. And that is why we're constantly trying to make sure that our associations act reasonably and in good faith. And oftentimes they do. And that's why you see multiple letters that go out before it gets turned over to the attorney. And we're trying to give the owner months of time to come into compliance, 4 different letters that have sent out. But unfortunately, at some stage, it's going to be turned over to the attorney. And so in those times, we want to make sure that we followed all of our policies. We've done everything by the book so that the court has no choice but to agree with what the association has done. And so that the association looks reasonable and not the owner who is complaining about what is being done. All right, so some problem areas that come up a lot. Retroactive and grandfathering. So grandfathering is not a legal term. Where you see it a lot though, is in maybe it's a rental provision or a short-term issue. And what will happen is, in order to get the amendment passed, the association will have to put something in that anyone who is currently renting their unit is not subject to this provision for the next 2 years or something along those lines. Now that can be somewhat problematic in terms of how you're keeping tabs of this. Typically what we're going to require is that any owner who is currently renting, they need to let us know prior to the amendment being passed or within 30 days of the amendment being passed, things like that. So it can be problematic, but it's a decent tool when we're trying to get something passed that might be controversial. Some of the most controversial amendments that go on right now are banning of marijuana or smoking, short-term rental bans, things along those lines. Those are really hot topic issues that get people fired up. Another issue that is a problem area is commercial vehicle. A lot of these declarations are written that say you can't have a larger than 3/4 ton truck in the association. Unfortunately, trucks no longer go by tonnage. 3/4 ton truck is not really a term that is still used. And when you're using these things, these kinds of terms like that, it's problematic because it encompasses a lot of today's current vehicles. Towing capacity or payload capacity has changed dramatically from the last 20 years as to what vehicles can do. Also, when we're talking about commercial vehicles, it might just state commercial vehicles. What does that mean? Does that mean any kind of writing on the car? Does that mean that the car can't have racks on it? Does that mean the car can't have some type of advertising on it? What does it mean? So when we're dealing with commercial vehicles, we want to make sure we have rules that specifically spell out what it is we're trying to look at. Next problem area, and this is a big one, parking on public streets. So typically, except in very rare circumstances, if a street is public, there's nothing the association can do to prohibit parking on that, regardless if their declaration says that you can't park on the street. So it is not uncommon that the declaration says there's no parking on the street, but the declarant had granted those streets over to the public, to the city. And therefore, once that's done, the association does not have the ability to enforce those covenants on that street. So that is a huge issue. People don't understand why it can't be enforced, but it comes up all the time. In terms of signs and flags, we touched on this briefly, but a new law was just enacted and went into effect about 4 months ago. But ultimately what it is saying is that associations can no longer deal with content of signs or flags. They do have the ability to limit the number and the placement of signs and flags. So what a lot of associations are doing is they are adopting sign and flag policies that allow for, say, a combination of 3 signs or 3 flags. Again, they can say whatever they want, but we're trying to limit the number. It used to be that you could limit political signs, you can limit all these things except for specific areas. We can no longer do that. We still highly recommend associations adopt sign and flag policies because the political issues are not going away. And unless you want someone to have 100 signs and 100 flags on their property, we would highly recommend you put some type of parameters on that. And so reach out to your attorneys to be able to do that. Other areas that you see is discrimination. Colorado Civil Rights Division gets brought in a lot. Children and familial discrimination are some of the big ones. Sometimes it may be a rule at the pool that says children under the age of 12 can't swim without adult supervision. Courts might find that to be discrimination against a child. One thing you can do to kind of help alleviate that matter is still have that, because there is a safety concern. But if the child, we put in the rule that if the child is able to swim or certified to swim or something along those lines, then they're allowed to do it. Again, we're trying to make these rules and these policies based on the actual conduct, not simply the age, because if you're just doing it based on age, that is likely going to be discrimination. We get a lot of FHA claims in terms of handicapped and disabled, whether it's they need a parking spot that's closer to their unit, or curb cutouts, or a ramp, things along those lines. Those happen a lot and can be problematic for associations in terms of not understanding what is stated in the FHA and what's required on both sides. And then we have a real big problem area, which is emotional support animals, pets, emotional support animals, service animals. So it's important to know emotional support animals and service animals are not pets. So any rule that you have in your declaration that is prohibiting pets or is related to pets is not going to be enforceable against an emotional support animal or against a service animal. And I think everyone would agree that service animals and emotional support animals serve a wonderful feature for people. If you need it, they are great. However, especially with emotional support animals, people have been abusing this a lot. Ultimately, they want to have what they want to have, and they know they can go online and get this animal a certificate that says they're an emotional support animal. And so there's been a lot of pushback back on that recently. You see it in the airlines, you see it in stores, and it's certainly trickled down to associations. There are certain things that you can ask for, but anytime that you are dealing with a reasonable accommodation regarding handicap or disability, make sure you contact your attorneys, because it is very factually specific and there's only certain questions you can answer or can ask. And there is a lot of liability that comes along with this. So if you were to deny an emotional support animal and it was actually needed, that is problematic. There's also some criminal statutes if you are falsifying emotional support animals. And each year we try and strengthen those and try and use those as best we can to ensure that those who actually need these ESAs or need their support animals, service animals, are getting them. And those who are trying to abuse the system are being punished for that. This next slide is, again, just talking about the support animal issue. Again, it is a huge issue. And as I said before, so there is a statute 1813-107.3, which is intentional misrepresentation of entitlement to an assistant animal, or 1813-107.7, which is intentional misrepresentation of a service animal. If that is taking place, that is a criminal act. And so we inform individuals who are requesting support animals or service animals of this and make sure that what they are doing is proper. So based on that, I promised you 7:30, 7:27. Let's try and get to some questions.
Great. We have some questions in the chat already, Jeff. Do you have that, or do you want me to read some of those to you?
It looks like I see 14 maybe.
That something like that. Yeah, that's more than I thought, but yeah, sure.
Well, so it looked like there's 14 with no. Okay. Is there a formal or legal definition of association? So yes, an association it's a common interest community. And so I can't give you a specific definition of it. Ultimately, if the association, if the entity has adopted a declaration, has adopted bylaws, has adopted articles of incorporation, and if there is some type of common element property, more than likely that is a common interest community and an association. So the short answer is yes, there is a specific way to determine whether an entity is an association or not. But it's going to be specific as to all of the individual facts. And then this is
Let me
Brenda.
jump in too, Jeff, just with some logistics on question
Yep.
and answer. So it's easy if we put them in the chat. That way we don't duplicate questions and we can read them and answer them as we have them. But if the chat is difficult for you for any reason, I absolutely understand that. There are lots of reasons that can be hard to access. And so if you need to, I invite you to raise your hand. You will find that button in maybe a few different places. Back to the top corner of your Brady Bunch square. If you hover your mouse over the top corner of your little box that has your picture or your name in it, you may have an option to raise your hand there. You may also have a reactions option on your menu. And in that reactions icon, you will find a raised hand button there. Worst comes to worst, pop on your camera and raise your actual physical hand because that always works too. So back to the chat, and then we will see what else we need as we go forward.
Perfect. The next thing that I show in the chat again is just a shout out for Boulder, but make sure that you guys are aware of the community mediation program. There's a link in the chat. You should copy that because it is very helpful and it is extremely cheap, not free, but very cheap. Next question is, we have a 1970s community with only basic CC&Rs, but it is subject to Kiowa. So it's a pre-Kiowa community. The CC&Rs do not have any provision requiring the exterior of homes to be maintained. Can the board adopt rules and regulations to cover this? It's possible. We'd have to see if there's something that we could tie to that, but more than likely what is going to need to happen is you're going to have to amend the declaration, which is going to require more than likely 67% of homeowner approval, and to actually amend the declaration and put a provision in there that requires maintenance of the exterior of the homes. That is going to be your most likely solution. Please comment on discrimination in this regard. Rules must apply to all, not some members. E.g., allow some to remove rock and flowers beds, but allow rocks for others. Could be paving stones allowed for some, not others, that kind of thing. So the first thing I would say about this is, gotta be careful what we're talking about with discrimination. Discrimination occurs when you are doing something different to a protected class. So it's a term of art. Now, this is really more of a selective enforcement kind of question. And agreed, all rules should be applied in the same manner to all members. Now, one caveat to that is as boards change, that doesn't mean that everyone's going to be treated the same way as a previous board had treated something. So if a prior board had allowed rocks in a flower bed or the removal of rocks in the flower bed, and this current board is not, that's not selective enforcement. And your ability to change that is by getting a new board in there. So there's something you have to be aware of, that just because one person has been allowed to do it does not mean that everyone is allowed to do that at any given time. Next question is, we have a house flipper who painted the house and brick without approval and outside our guidelines. We sent a violation about this letter about the house and brick, saying they should submit to the ACC for the paint changes they want to make to comply. They have not made any change nor submitted any plans, and they painted the shingles without approval. We could probably fine these folks for non-compliance, but it would make sense to first let them know we have put a violation letter into the title company packet when the house is sold. So the first thing I would say that you should do is you need to follow your enforcement policy. So you should first send the courtesy letter and then the fine letters. You should go through that whole policy. And then once you're done with that policy, you should turn it over to the association's attorney. The association's attorney will likely file a covenant enforcement lien, and then we'll also send a demand letter and move forward with the lawsuit. Simply waiting or trying to do this yourself and not taking those steps is more than likely going to lead to the association not being able to enforce it. And my guess is the property would change hands before the association even knew. Associations are constantly trying to save money by not using attorneys, which makes sense. You want to save money, but what usually happens in those is you end up spending 10 times as much money because the association messed up in some regard and didn't do it properly. You're better off following your enforcement policy, sending it to the attorney. And maybe you tell the attorney you don't want them to file a lawsuit, you just want them to file the lien and send the demand letter. They can work with you in those ways to try and minimize costs, but you need to be going through the enforcement process. If you're not going through the enforcement process, the board is probably subjecting itself to some type of liability in the association for failure to enforce the covenants. How are boards for high rises, condos supposed to think about security? We have key fobs, cameras, a package room. It doesn't seem realistic to not take responsibility for at least some features, like you said. So with a high rise condo, again, we don't guarantee anyone's security. So yes, we have key fobs, cameras. Maybe if you have cameras, you should have a camera policy. If there's a package room, again, we don't ensure that the package room is safe or that people can't come in there and steal. Ultimately, you have your basic things that, yes, we have locks, we have security in those terms, but we don't have typically a security guard standing there. We don't have someone that is there ensuring someone's safety. So in terms of property, yes, we might have some concern for the property in terms of safety along those lines of we're going to require people to get in with just a key fob or something along those lines to help make sure only our members are getting in and their guests. But outside of that, we're not ensuring the security of an individual. We don't have that ability. We aren't a police force, so we don't want to do that. That's not to say that we want to have doors that are unlocked and not be maintaining the things that we have, but we aren't ensuring anyone's safety. Our HOA relies on city ordinances. Is this relying on city to enforce ordinances on HOA property? Please comply. So I'm not exactly sure what your documents say, but if your documents say something along the lines of it's a violation to not be in compliance with the city ordinance, you probably don't have the ability to enforce that, because the HOA does not have the ability to determine if someone is not in compliance with the city. And the city is not going to enforce your governing documents. The city is only going to enforce their own ordinances. So if you want to mirror them, we should have rules and regulations that mirror them, and that would allow the association to enforce their own rules, and those rules might mirror what the cities is, but we're not going to be able to enforce just city ordinances if we don't have more clarification on that. And the city's never going to come in and enforce our governing documents. If you require homeowners to paint their houses.
I'm sorry,
Yep.
Jeff, can I jump in on that one too? Just
of course.
As a staff member of the city who often works closely with code enforcement on various issues. The city ordinances are always, when you're looking at sort of that hierarchy of documents, city ordinance is the local law. And so that is considered above. So if there is something that's allowed by your HOA covenants, but is in violation of city ordinance, the city can write you a ticket or a citation for that, even if it's allowed within your covenant documents. My code enforcement teams have often asked me to say that out loud in these types of meetings so that you're aware that just because it's in your rules doesn't mean you can supersede city law. So it's important to sort of know what that balance is and make sure you don't have things in your covenant that would lead people to believe something is legal that is not legal.
And on the flip side of that, just because the city allows you to do something does not mean that it's allowed in the HOA.
That is correct. Yep.
Sure.
Yeah. So the laws, the HOA would be an additional layer of restriction, but it does not release you from the legality of city laws.
Yeah. And the difference between that is the HOA. So the HOA may say it's fine. And they may approve it. So they're not going to obviously do any enforcement. But if it violates the city's ordinances, the city is going to come in and enforce their ordinances, their laws. So it is important that it's just like everything, just because you get authority from one, and it's the same if you have a sub-association and a master. Sub-association might approve something that the master association is a violation of the master association, and although the sub-association can no longer enforce it, the master can. So you have to be aware that there are multiple layers of people that can enforce different restrictions. Okay, if you require homeowners to paint their house, is there a recommended time period because of the expense? Short answer to that is no. There's no recommended time period. If an owner comes to a board on a case-by-case basis and says, because of these circumstances, maybe I have a child who's sick in the hospital, maybe I lost my job. Perhaps the board will give them an extension, but ultimately it's the homeowner's job to keep that house in good repair the entire time. So as soon as it falls behind, they should immediately be bringing it back into compliance. Can you give me a brief to get my fellow board members to hire an attorney for a disability FHA claim? I'm the only one saying we must use an attorney. None of us are attorneys. So in terms of using an attorney, anytime an FHA claim comes in, you should get an attorney. We have seen many cases where an association has become liable for hundreds of thousands, if not millions of dollars for disability claims, simply because they've waited too long to respond to the owner. It's happened with support animals, service animals, where the animals weren't even not allowed, but they were getting fines for it. Anytime you are dealing with something like this, disability, I mean, this is federal law. This is big time. There are a lot of liabilities that come along with that. And you're also possibly exposing yourself as a board member to some type of maybe even personal liability if you are not doing what you should be doing in terms of the association. So if you're acting outside of your scope, I mean, usually a board member does not have any kind of personal liability, but if they're acting outside of their scope, that is problematic. So I would make sure when there's a discrimination claim, a disability claim, FHA type thing, you have to get that to your attorney so that they can advise you. And again, it may not be an overly expensive advisement. It might just be simply, hey, you need to ask these questions. We can send the letter. Maybe it's a $500 thing, but if that saves you, that $500 saves you 500 grand, that's obviously a great decision. So I would always make sure anytime you're dealing with disability, discrimination, that needs to go to an attorney and get it to an HOA attorney, and they will let you know what the next steps are. Those are all the questions I have in the chat.
That's all I'm seeing too. So we do have some time. Janice, I saw your camera come on. I can't see you, but I'm wondering if that is an indication that you have a question, Janice Jennings. And also, Kate, I just saw your camera come back on. Do you have a question? Great. Yep, I'm giving you your mute button. There you go.
All right, I'm a pretty new member in the HOA, and one of our members told me, or one of the directors said that we have several homeowners that are members of several HOAs. They are not on our plat. Can we discontinue them from our plat? We think maybe they want to be on ours because we have a pool.
So can you so they're either a member of the association or they're not a member of the association.
Two associations.
Well, yeah, so there's probably a master association and a sub association.
They belong to the association where their house is. And then somehow they got a membership with our HOA. And they are not on our plat.
Yeah, I mean, so without knowing the details, I don't know. I mean, so when you're talking membership, the only way that they can be a true member of your association is if they are on part of the declaration. So if their property is covered in the declaration. Now that's different. It's possible that at some stage your association was selling pool memberships or something along those, or had some type of limited social membership. With that, it's likely there's going to be a document that's going to control that. And so that document would be what you'd have to look at as to whether or not it could be terminated or not. But that's something that you're going to have to go get legal counsel to look at these documents and determine first, are they part of your association? Do they have any right? And two, if they don't, then what is our ability to terminate whatever rights they might have?
Okay. All right, thanks.
Of course.
Sorry, that's Janice letting me know in the chat that she does not in fact have a question. So thanks for that, Janice. I appreciate it. Others with questions either in the chat, we have one coming up in the chat. I'll just remind you all, if you can pop it in the chat, you can raise your hand using your reactions button. I'll demonstrate, it looks like that. Or you can turn on your camera and raise your physical hand. Do you want to jump on that question in the chat, Jeff?
Sure. Can you cover fines again? If the covenants don't mention fines, can you still have fines? In other words, can fines be defined in our rules and regs? Yes, so typically what's going to happen is in your declaration, there's going to be a provision that's talking about enforcement. It's not going to probably mention fines specifically, but you have to have something that says you have the ability to enforce. Where your fines are actually going to be listed is going to be in your enforcement policy. It may be in rules and regs, but it should be in one of the 9 policies, which is the enforcement policy. And so that's going to have your schedule of fines, which is going to say the first fine is a courtesy notice, or first issue is a courtesy notice. Second is going to be a $25 fine. Third is going to be a $50 fine. Fourth is going to be a $100 fine. So it would not be common at all for there to have monetary value of fines in a declaration, because those are going to be things that change as the years go by. What are some of your favorite examples of ways to have a healthy HOA and a happy neighborhood? I mean, honestly, the best way to do it is to have the more community engagement you can have, the better. The more that people go out and actually talk to their neighbors, and it's harder in the COVID times right now, but are having that 4th of July party, or having a sleigh ride through the community in December, are doing things along those, that's the best way. I mean, with anything, actual interaction with people, when you put names to faces and they're no longer just this big bad entity, that is the best way for communities to get along and to grow. And you have to also understand that people are going to disagree, and they should disagree, and disagreements lead to better communities as long as everyone is being respectful. Ultimately, people don't always think about things the same way. It's good to hear those differing opinions, take those in, and then move forward and try and come to a conclusion. It might be like most settlements, everyone's not going to walk away happy, but as long as everyone is content with what took place, that's usually a good result. Can you discuss Kiowa again? Are all HOAs covered by this? Our HOA was established in the early 90s. So Kiowa is the Colorado Common Interest Ownership Act. It is going to cover almost all associations, but it might cover them in different ways. So any association that is formed after 1992 is called post-Kiowa, and it is going to be subject to all of the Kiowa provisions. There are a couple exceptions to that. If it's a limited common expense community, or say possibly the association has less than 10 units, it's possible that all of Kiowa may not apply to them. For a limited common expense, very little of Kiowa applies to them, but some still will. In terms of a pre-1999, 1992 community, they're called pre-Kiowa communities. They are subject to the vast majority of Kiowa, but not everything. Things that will be different are going to have to do with budget ratification, and some other things along those lines. So if you look at the beginning of Kiowa, and it's in 33.3, I want to say 117, it's going to talk to you about what provisions apply to pre-Kiowa communities. So if you are a pre-Kiowa community, you can look and see what exactly applies to you, or you can ask the attorney. But the vast majority of Kiowa is going to apply to all associations. And being established in the early 90s, it's really going to be questionable. If you were done in 91, then you're a pre-Kiowa community. If you were done in 93, all of Kiowa is likely going to be applicable to you. And also you'll see pre-Kiowa communities that when they amend and restate their declaration, they will opt into all of Kiowa. So all of that is possible. Any other questions?
I just shared in the chat a message full of typos about my the Office of Neighborhood Services. This is for City of Boulder residents who have joined us tonight. We had a neighborhood grant program for several years that was paused during COVID, both for budget reasons and for public health recommendation reasons. And that program will be revived in 2022. We will still need to watch those public health recommendations on what those proposals hold, but those are funds that are there for neighborhoods to come up with ideas to get your neighborhoods together and build community, just as Jeff was saying. There's a specific fund for block parties, and then there's another fund that is specifically for sort of creative ideas to build community in your neighborhoods. We've paired neighborhoods with artists before to bring participatory arts experiences to neighborhoods. We've had neighborhoods work with our neighborhood speed management program to do street murals as part of traffic and speed mitigation. So there are lots of ideas that I would love to talk with you about if you're interested. So you can reach out to me. I put a link to the neighborhood services homepage. From that page, there's a link to the grant page that is dormant right now, but we will be reviving it in January as the program comes back online.
It looks like there was another question that popped up. Currently voting on no short-term rentals. There's no language about grandfathering, how to handle. So honestly, if the association can pass the amendment without any type of grandfathering, that is the best case scenario for the association. The only time that we are going to use something like grandfathering is if it is not going to pass. But it's much better to have a clean break of there is just simply no short-term rentals moving forward.
Apologies, my mouse has frozen, so I can't get to any of my controls.
Another short-term rental question. I read something about some communities using rentals of less than 30 days not allowed to prevent these. So that is typically what the no short-term rentals are going to be like. It might be 30 days, it might be 6 months, it might be a year. All of those are going to be considered STRs. You could go shorter. I mean, they can set it at whatever time frame they want, but that is 30 days is the kind of the usual one of we're not going to allow rentals of less than 30 days. They may specifically call out things like VRBO or those kinds of places, but typically it's going to be a date thing like 30 days. It might be as short as 7 days. Those are what the short-term rentals are going to be talking about. How would you handle a situation where a longtime homeowner needs to paint the house but doesn't have the means, finances to do it? I mean, these are always difficult. Unfortunately, from the association standpoint, if it has been a long time thing and it hasn't happened, the association needs to treat this owner the same way they treat any other owner, and they should be enforcing and going through their policy and requiring them to do it. Now, that wouldn't prohibit individuals in the community or individuals on the board not acting as the board, trying to get people together to either raise finances to help this individual or actively go out there and actually paint the house for them. I mean, there's lots of ways that you can do it, but from the association standpoint, they need to be treating this homeowner like any other homeowner and enforcing it and forcing them, unfortunately, to paint the house.
I'll jump in there too. I know in Boulder, we have a lot of mixed HOAs where there's affordable housing properties within the market rate properties in an HOA. And so we know that there's a lot of creative ways that those HOAs have come up with to make sure that the folks who are in affordable housing who might have less disposable income than other folks are still able to comply or are able to get exceptions in various cases. So I would also encourage some case-by-case dialogue with your homeowners and staying within your legal bounds so that your other homeowners don't get frustrated.
All right. Well, if there are no other questions, I might, hang on, here we go. We have a second floor condo owner wanting to pass wiring beneath the ground floor condo in order to set up an electric vehicle charging station. Can the HOA deny on the basis of not allowing wiring to pass through the crawl space? So that's going to touch on a couple of different things. There are statutes that specifically deal with the electrical vehicle charging station. There's also issues. Most associations, I mean, again, it's going to depend on your documents, but most associations are going to allow some type of an easement across common elements for owners to be able to run services. So, I mean, this is something that you probably are going to have to look at. If the crawl space is an individual owners and not a common element, that'll change it. But ultimately, it's going to be specific to what your documents say. And your attorney is also going to want to look at the electrical vehicle charging station statute, because that also is very important. More than likely, just on what you're saying, my guess is that the owner would be allowed to do this But it is possible that the association could prohibit it depending on what's in your governing documents. In terms of what state legislation do you anticipate in 2022? I think you're going to continue to see kind of these smaller things passed, where like this year it was the sign and flag policy. There was a document retention that was passed. They have tried in the past to do larger changes, and those have been shot down pretty quickly. I think you'll see kind of these still smaller amendments to Kiowa that are dealing with transparency. Transparency is always a big issue, and a great issue that it's the more that we have, the more that associations know that they need to be doing, I think the better. There's just a lot of ambiguity in Kiowa. So I think you will see more kind of smaller issues that are dealing with transparency geared towards associations. Quickly to summarize the sign policy law, again, ultimately associations can no longer deal with content. So if a homeowner wants to put up, I love Trump, or I love Biden, or I hate my HOA, or derogatory terms about my board president, or I hate my neighbor, or I love everybody, all of those signs have to be allowed. We can no longer deal with the content of a sign. So what we can deal with is the number, the size, and the location. Those are kind of the things that we can still do. So you should have a sign policy simply to deal with the number of signs that should go up on any specific property. Perfect. Well, if there aren't any other questions, I'm going to try and run and pick my son up at basketball practice before he sits there for too long. But thank you guys very much for having us. Hopefully this was informative to you guys, and thanks for sticking around.
Yeah, thank you so much, Jeff, for joining us tonight. We really appreciate you being here and want you to get your son on time. So I encourage that. And I did record. Thank you, Bob, for the reminder. And we'll send out a link. Give me till early next week because I'm hosting another type of event on Saturday that I'm a little crazy for tomorrow. So it'll be early next week. You'll get an email from me with the slides, a copy of the slides again, as well as a link to the recording. So otherwise, thank you all so much for being here. You're getting a lot of appreciation in the chat, Jeff. So we know that folks found this valuable this evening. Please always feel free to reach out to me and let me know if you found this valuable, other topics you might find valuable. As I look at 2022, I'll be working with Melissa at Altitude to sort of figure out what we offer next year. So
perfect.
Let me know.
Thank you, Brenda.
Thank you, everyone. Bye-bye.